If you asked a few random people to name a situation that wouldn't be protected under the First Amendment's freedom of speech clause, there's a pretty good chance at least one of them would mention the example of someone shouting, "Fire," in a crowded theater, when there's no fire. Over the last century, the scene has been used far and wide to illustrate that if your free speech harms people, you can still end up in the defendant's chair. But, as is so often the case when it comes to interpreting the law, it's really not that simple. If you found this topic intriguing, make sure to like this video, subscribe for more insights, and share your thoughts on free speech in the comments below. We'd love to hear from you. Panic Room. When people first started discussing human fire alarms at packed gatherings, it was less about constitutional debate and more about societal menace. During the late 19th and early 20th centuries, there were dozens of tragedies, mainly in the United States but also abroad, where false shouts of fire provoked panic that resulted in multiple innocent and avoidable deaths. In 1913, for example, residents of Calumet, Michigan, held a Christmas party for the children of copper miners on strike. Hundreds of people gathered on the second floor of Italian Hall, and when an unidentified perpetrator, possibly motivated by anti-union sentiments, yelled, "Fire!" they all rushed to the stairs. The stampede claimed 73 victims, most of whom were children. The fear of fire wasn't unfounded, because not all buildings had sprinkler systems, neon exit signs, and capacity limits. Plenty of fatal blazes occurred. More than 600 people died in Chicago's Iroquois Theater fire in 1903, even though, ironically, that building was actually thought to be fireproof. In short, shouting fire in a crowded theater was an idea firmly entrenched in the public consciousness by the time judges co-opted the phrase for legal arguments on First Amendment rights. Discussing fire in a crowded courtroom. The axiom became popular in legal spheres after Supreme Court Justice Oliver Wendell Holmes, Jr. mentioned it during Schenck v. United States in 1919, but he wasn't the first person to use it in court. As Carlton F. W. Lawson pointed out in a 2015 article in the William and Mary Bill of Rights Journal, U.S. Attorney Edwin Wirtz had uttered a lengthier version of it the previous year while prosecuting activist Eugene Debs in Ohio. In fact, because Holmes ruled on Debs's appeal the very week after the Schenck case, he may have even gotten the idea from Wirtz. Each case involved a violation of the Espionage Act of 1917, which essentially made it punishable to do anything that interfered with U.S. military operations, including speaking out against the draft. Debs, a pacifist who opposed World War I, was under fire for a speech he had given in Ohio. In another case, Charles T. Schenck, the Socialist Party of America's General Secretary, appealed his case to the Supreme Court after being convicted for passing out pamphlets that encouraged men to refuse the draft. Holmes upheld the convictions for Schenck and his co-plaintiff, Elizabeth Baer, a fellow member of the Socialist Party, as well as for Debs. He justified his ruling on the Schenck case with the explanation that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. But while his analogy struck an emotional chord, it really had nothing to do with constitutional law. The crowded theater statement in Schenck never amounted to any kind of binding standard or doctrine, Nashwa Gwaley, a media and First Amendment lawyer, told Mental Floss in 2020. It was basically a bit of emotionally charged extra flair from Justice Holmes, outside the official legal determination of that case, a powerful image that endured outside its context. It was not a high point in American jurisprudence. So, revengeance is fine. What Holmes said after it, however, did become a standard for future free speech arguments. He stated, "The question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent." For the next 50 years, clear and present danger was the accepted and slightly vague metric for discerning if spoken or printed material was protected speech. Then, in 1969, the Supreme Court replaced it with something clearer. The case, Brandenburg v. Ohio, concerned a Ku Klux Klan leader named Clarence Brandenburg, who had broken Ohio's law against advocating crime, sabotage, or unlawful methods of terrorism for political purposes. In his offending speech, he had mentioned the possibility of revengeance if the federal government didn't stop suppressing the white Caucasian race. Brandenburg appealed his guilty verdict all the way to the Supreme Court, which overturned the ruling on the grounds that his threats were too ambiguous to legally amount to more than mere advocacy of violence or lawbreaking. In order for speech to cross that line to incitement, it must be directed to inciting or producing imminent lawless action, and likely to incite or produce such action. As Gwaley explains, judges interpret this standard far more narrowly than many would presume. While individual institutions may condemn hate speech, for example, it's not punishable by the government as incitement unless it clears a high bar combining intent, likelihood, and immediacy of a resulting crime. And even that high bar can be subject to interpretation. When free speech is the least of your worries, you might wonder if falsely shouting fire in a crowded theater falls outside the conditions of imminent lawless action, and therefore falls under First Amendment protection? The short answer is that it depends on the circumstances, but here's the long answer. If you get arrested for doing that, the charges brought against you might make the question of free speech totally irrelevant. The falsely shouted warning, while technically speech, could potentially violate a state's criminal laws against disturbing the peace or disorderly conduct, whether or not it provokes a stampede, for instance, Gwaley says. And if there is a stampede in which somebody dies, you could be charged with involuntary manslaughter. In other words, even if there's no law in your state that explicitly prohibits you from crying fire in a theater, there are other laws you might still have to worry about. Shouting bomb or gun in public would put you in a similar situation. In May 2018, for example, officials had to evacuate part of Daytona Beach International Airport after a man ran naked through the building screaming about a bomb in the women's bathroom. There was no bomb, but he was charged with false report of a bomb, criminal mischief, and exposure of sexual organs, among other things. In that case, no self-respecting lawyer would advise him to claim his actions were protected by the First Amendment. That said, there's good news for anyone whose panicked cry is an honest mistake. Someone who shouts a warning in genuine error, with an intent to galvanize movement to safety, would not be properly punished for that speech, Gwaley says. And if Oliver Wendell Holmes Jr. has taught us anything, it's that not every word a Supreme Court justice says automatically counts as constitutional doctrine.